It's live, right? Okay, done. Thank you. Hello guys. Hope you are able to see. I hope everything is working fine. If you guys have any doubts, I thought, yes, why not directly go live? And yes, if you guys have any doubts, we can discuss that as well. And yep, without any delay, let us start with your RTPs. I hope you guys have done with your last 3 days schedule, whatever we are done. And that part is sorted is what I believe. But if you guys have any doubts, you can please let me know and I'll try to answer that. So to start that, I got the last 5 RTPs. Yep. More or less in certain places, I'll try to tell you that these are the important topics. Try to remember them because they have repeatedly asked them. Based on that only, I've prepared the most important topics as well. So make sure you guys watch that most important topics part. Do not skip that at any cost. It is very, very important because on that we see a lot of questions being framed. Yes, so do not skip that part. And I hope I am audible to all of you. So let's start. So wherever possible, you guys also try to answer and you will understand where you guys stand. Yeah. Okay, we'll start. Mr. Parth applied for a job as principal of a school. The school management decided to appoint him. One member of the school management committee privately informed Mr. Parth that he was appointed, but official communication was not given by the school. Later, the management of the school decided to appoint someone else as a principal. Mr. Parth filed a suit against the school for cancellation of his appointment and claimed damages for loss of salary. State with reasons. Will Mr. Parth be successful in suit filed against a school under Indian Contract Act? So people, it is clear. It is rules of acceptance. The acceptance here was not formal. It was informal. Point 1. Point 2, people. Acceptance should always be given by the person, that is promisee. He should give the acceptance or any other person authorized by him. A random person cannot give an acceptance, right? If I have made an offer to you, you have to give an acceptance, or if it's a general, then anyone can give. But in school, it's not like an attendant, a clerk, a student, or a parent sitting there. They cannot give an acceptance, right? It has to come from a formal person. It has to be by a promisee, or it has to be by a person, any other person authorized by him. So on that ground, I can tell people this is not a valid contract and you will not get any right in this particular suit. So my answer will be whether Mr. Parth be successful? Absolutely no. He will be unsuccessful. That will be my conclusion. I will write in conclusion, Parth will not be successful, referring to my provision. Clear? Rules of acceptance. Sarthak is employed as a cashier on a monthly salary of 50,000 by ABC Bank for a period of 3 years. Mohit gave surety for Sarthak's good conduct. After 9 months, the financial position of the bank deteriorates. Then Sarthak agrees to accept a lower salary of 40,000. So earlier the guarantee was given for 50,000 salary. Now it has become 40,000. Okay, per month from the bank. 2 months later, it was found that Sarthak had misappropriated cash from time of his appointment. What is the liability of Mohit taking into account the provisions of Indian Contract Act? Hi Nandu, hi Nitin, hi Sai Charan. Yeah, hello. So in this case, what happens, sir? If you guys remember, people, the question is coming from your indemnity and guarantee. In guarantee contracts, whenever there is any change in the contract between, we would have seen it like this. If at all there is any change between, imagine, principal debtor and the creditor. If at all there is any change between them, and if it is not informed to the surety, to the guarantee, if any material change happens, people, then the surety will be discharged from the contract. So in this case, there has been a material variance, people. There has been a change in the contract, which is not yet intimated to the surety. The guarantee is not yet intimated, and that will be my provision. So my conclusion, what will be my conclusion? My conclusion will be, people, in this case, what they're asking you, what will be the liability of Mohit? Mohit is who? The surety. The liability of Mohit has come to an end because of variance in the contract without the consent of the surety. That will be my conclusion. I hope this is clear. Hello, David. Yeah, Rahul was, I hope that is clear. Are you getting how I'm phrasing my answer? Are you getting? My first part will always be provision. My last part will always be conclusion. Opening statement should be law always. Are you getting my point? Yes? Hello, Navya. Rahul was a DJ at a 5-star hotel. DJ Macha. As per the contract, he is supposed to perform every weekend. Okay. That is twice a week. Rahul will be paid 2,500 rupees per day. However, after a month, Rahul willfully absents himself from the performance. Taking into account the provision of Indian Contract Act, you have to answer these three following. People, whenever there is one question with three answers, and if the question is belonging to a same provision, have one provision and write a conclusion like this. 1, 2, 3. So my provision is same here. What is this? Breach of contract. Does the hotel have the right to end the contract? Does the hotel have the right to end the contract? Does the hotel have a right? Answer is yes. Because if you failure to perform the contract, this person did not show up. Can I end? Answer is yes. If the hotel sends out a mail to Rahul that they are interested to continue the contract and Rahul accepts, can the hotel resign the contract after a month on this ground subsequently? People, always remember, breach of contract, failure to perform the contract. I have a right to cancel the contract or continue the contract either by express words or by conduct. I can continue. But once I continue, people, later on, I cannot cancel the contract for the same grounds. So here, once I continue, I cannot cancel the contract. I cannot go back to the contract. Correct? Sir, provide the answer in writing. Rakesh, tomorrow, the last day will be only practicing answers. We will be practicing on how to write. Now today, I'll have to do what? We are thinking of doing 5 MTPs. In one MTP, 23 questions are there. So put together will be what? 120 questions. So today I'll not be able to write and practice, but tomorrow's session is for that. We will be practicing and writing. Is this clear? Sir, we are scared about law only. Thank you for your efforts. I know that the law has been scaring all of you guys. That is why every day I've given you a schedule so that you guys will learn the subject with me and you will also be able to finish the subject with me. Yeah, see, consistency, persistence, people, will make you guys flourish. The third thing where I am trying to come, these two are with you. Consistency and persistence is with you. What you do will, the result will give you. The third thing is, people, the lack of aim. So you want to do, but you don't know what to do. And that is the reason every day I'm trying to come and tell you, do this, it will help. Do this, it will help. So if you guys have been looking at whatever the videos I've been uploading, you just see your past papers, you see past RTPs, you see now past MTPs. The topics that is repeating, the common topics are coming. So the chances of these questions coming again in your exam is always there, 100%. That's why I'm saying no more questions and go. Like now, just sit back. I'm reading the question. You try to predict your answer sitting there. And I'll tell you whether it is right or wrong. Correct? In which of the case, termination of contract or continuance of contract, can the hotel claim damages? So remember, people, either the hotel, whenever there is a breach of contract, what are the two remedies you have? You can cancel the contract immediately or you can continue the contract. In either case, people, you have a right to claim compensation. So in this case, the company, the hotel has a right to claim compensation in both the cases. Clear? Clear? Bhagya sir, अब की बार पेपर टफ आएगा क्या? No Bhagya, it will not be tough and all. Why don't we prepare to the toughest paper and then paper turns out to be the most easiest one? Correct? Examine whether the following constitute a contract of bailment or not. So what is bailment, people? Temporary transfer of possession of goods from one person to another person. Once the objective is achieved, the goods will be transferred back or disposed of according to the instructions. So Vikas parks his car at a parking lot, locks it and keeps the keys with himself. People, remember, this is not transfer of possession. It is just a transfer of custody. The car is still under your control and hence this is not considered as bailment. It is just a transfer of custody. Next one, seizure of goods by customs authorities. Of course, they have seized it. The control is with them now. Yes, this will amount to bailment. Clear? Sir, May 25 maths was tough now. Nothing like that, people. We'll now, when we are doing so much, then why paper will be difficult? Let us make sure we prepare to the toughest extent, no? Yeah. Mr. Sanjay Kothari was a big businessman having two sons, it seems, and one married daughter. Okay. He decided to gift his house to his daughter. Okay. For this purpose, he called his lawyer at his house and made a written document. See, when you're reading the question only, you should know there is a son, there is daughter, there is a house, there is a written document. Now, I'll not even read the next 5 lines. What will be the question be on? Question will be on exceptions to quid pro quo, natural love and affection. Yes. Written document for such gift. The lawyer advised him to get the transfer document properly registered. When they both were going for registration of the document, they met an accident and both died. Later, the daughter found the document and claimed the house. Explain whether she can get the house as gift under the Indian Contract Act. Answer is no. Because, people, I'll tell you 3 reasons why this is not gift, but why it is considered as a love and affection. Because, people, when the parties stand in a near relationship, father and daughter, when the document is written, people, it should be registered, people, and only then it can come under exceptions to quid pro quo. A contract without consideration will be valid if at all it is entered between a near relationship, and if it is for what is that? Natural love and affection, and people, the document has to be written and registered. Here the document is not yet registered and hence the daughter cannot claim the house based on this particular document. Is this clear? Okay. Mr. Ayush, the employer, induced his employee Mr. Bobby to sell his 1-room flat to him. See, employer, employee. He induced. See, what is the question on? Undue influence. Correct? At less than the market value to secure promotion. Mr. Bobby sold the flat to Mr. Ayush. Later on, Mr. Bobby changed his mind and decided to sue Mr. Ayush. Examine the validity under Indian Contract Act. Of course, people, undue influence, and hence the contract is voidable. Simple. Mr. Suraj promises Mr. Manoj to paint a family picture for 20,000 and assures to complete his assignment by 15th March 2023. Unfortunately, Mr. Suraj died in a road accident on 1st March 2023 and his assignment remains undone. Can Mr. Manoj bind the legal representative of Mr. Suraj? Who can perform the contract? Who can perform? Promiser himself. When the promiser himself has to perform the contract, whenever the contract involves any special skill, talent, confidence, in such case, only the promiser can perform and legal representative cannot perform. In this case, drawing, painting involves a skill and talent and hence legal representative will not be liable and this contract is a void contract because of impossibility of performance and hence whatever benefit is taken should be returned. So if 20,000 has been taken, you have to return it. Okay. Suppose Mr. Suraj has promised to deliver some photographs to Mr. Manoj, meaning I have taken some photos, it seems. I have said that I will sell that to you. Now people, whether I am there or not, the photographs at my home, I can sell it, right? That does not require any special skill or talent because it is already taken. It's a photograph, it is already taken. So that, yes, the legal representative will be liable to give it to Mr. Manoj. Yes, you will be liable. Yes, sir. Okay, next one. Rahul, I'll tell you, I think we have such questions also on subsidiary company. We'll take it up when it comes. Prakash reaches a sweet shop and asks for 1 kg of burfi if the sweets are fresh. Seller replies, sir, my all sweets are fresh and of good quality. Prakash agrees to buy on the condition that first he tastes 1 piece of burfi to check the quality. The seller gives him 1 piece to taste. Prakash, on finding the quality is good, asks the seller to pack. On reaching the house, Prakash finds that burfi is stale, not fresh, while the piece tasted was fresh. Now Prakash wants to avoid the contract and return the burfi to the seller. State with reasons whether Prakash can avoid the contract. Yes, people, whenever the goods are sold in sample, I gave you 1 piece of burfi. The bulk has to correspond to the sample. The sweet I tasted in the shop was fresh, but the bulk was stale. It was rotten. So the bulk did not correspond to the sample. See, provision, I'm not telling it like a story. I'm not telling it morally, because of the story I feel this is how I need to write. That's where people go wrong. You should not write the law because you feel so. With provision, you have to support the answer. Goods corresponding to sample did not match with the bulk. On that ground, yes, I can. Will your answer be different if Prakash does not taste the sweets? What if sample was not given at all? My answer will not change because he has claimed that all my sweets are fresh and of good quality. This is called as what? Sale of goods by description, and description is not met if sample is not there. So in that case also my answer will not change. You are liable. I can get my money back. Simple. Okay. Akansh purchased a television set from Arvind, the owner of Gada Electronics, on the condition that first 3 days he check its quality, and if satisfied he will pay for that, otherwise he will return the television set. On the second day, the television set was spoiled due to an earthquake. Arvind demands the price of a television from Akansh, whether Akansh is liable to pay the price. People, sale of goods under sale or return basis. I have 3 days time. In the 3 days, if I have taken proper care of the goods, then my liability as a bailee will come to an end. So in this case, if any unforeseen event happens, earthquake, anything, which is not in my control, so as a buyer, I am not liable because I have 3 days time. The ownership has not yet passed. The ownership, when will it pass? Whenever I've given that consent, or if I keep the goods beyond the return period, or if I do something equivalent to an acceptance. I have not done any of these 3, and hence the ownership has not yet passed. So the person, the seller himself is liable. I hope this is clear. They online, no? I hope it is clear. Mr. Arun contracted to sell his Swift car to Mr. Nikhil. Both missed to discuss the price of the said Swift car. Later, Mr. Arun refused to sell his Swift car to Mr. Nikhil on the ground that agreement was void, being uncertain about the price. Does Mr. Nikhil have any right against Mr. Arun under Sale of Goods Act? See, if the question is asked under Indian Contract Act, the answer is different. Yes, it will be vague because you have to decide the consideration. But Sale of Goods Act, we clearly have a section 9, that is ascertainment of a price. So people, always remember, people, in ascertainment of a price, if the price is not agreed, on that ground, you cannot call the contract as void. You have to pay what is reasonable. So if the buyer pays what is reasonable, then the contract will be valid. This is clear, all of you? Okay, done. Next one, Mr. Shankar sold 1000 kgs wheat to Mr. Ganesh on credit of 3 months. Wheat was to be delivered after 10 days of contract. After 5 days of contract, see this was there in MTP. At least 2 times it is already given in MTP. Again coming in RTP. Yeah, after 5 days of contract, a friend of Mr. Shankar secretly informed him that Mr. Ganesh may default in payment. On the information of friend, Mr. Shankar applied the right to lien and withheld the delivery. With referring to the provision of Sale of Goods Act, state whether Mr. Shankar was right in his decision. What would be your answer if Mr. Ganesh became insolvent within 5 days of contract? People, right to lien can be exercised when the goods are not sold on credit, or if sold on credit but the credit period is over, or when the buyer becomes insolvent. In this case, the goods are sold on credit of 10 days, but this person is cancelling it in 5th day only. Credit period is not yet over. So people, I do not have a right to lien because he has not yet become an insolvent. You are thinking he may default. It is not yet certain. So the seller here cannot exercise the right to lien because the credit period is not yet over. In the second case, what if he becomes an insolvent? Yes, it gives me a valid right. That time I can cancel the contract. I can. As an unpaid seller, I have a right to exercise lien. Done. Moni and Tony were partners in the firm, Measures Moto and Company. They admitted Sony as a partner in the firm and he is actively engaged in day-to-day activities of the firm. There is a tradition in the firm that all active partners will get a monthly remuneration of 20,000. But no express agreement was there. After admission of Sony in the firm, Moni and Tony continued getting salary from the firm, but no salary was given to Sony from the firm. Sony claimed remuneration. You guys decide whether Sony will get it or not. Your answer should just come like this here. What? Can a partnership firm pay remuneration to the partners? Is it possible? The answer is yes. If your partnership agreement provides. Sorry, in this case, it does not provide. If it is customary in the partnership to pay the remuneration. In our case, it is customary because these two partners have been receiving the remuneration for a very long time. So it has become a custom. On that ground, Sony will also be eligible to claim remuneration. Is this clear? Pakka, 100% done. Mr. Ram and Mr. Rahim are working as teachers in Ishwar Chand Vidyasagar Higher Secondary School, Ababa, and also very good friends. They jointly purchased a flat which was given on rent to Mr. John. It was decided between landlords and tenant that the rent would be 10,000 per month inclusive of electricity bill. It means the bill will be paid by landlords. The landlord by mistake did not pay the electricity bill for the month of 2021. Due to this, the electricity department cut the connection. Mr. John has to pay the electricity bill of 2,800 and 200 as penalty to resume the connection. Mr. John claimed 3,000 from Mr. Ram, but Mr. Ram replied that he is liable only for 1,500. Mr. John said that Mr. Ram and Mr. Rahim are partners, therefore he can claim the full amount from any of the partners. Can he claim, people? If at all it is a partnership that is there between these two people, then you can claim a complete, money from one partner. One person. In this case, answer is no, people. We know for a fact, always remember the chances of question coming between partnership and co-ownership is always high. As a student, if I were a student, I will never skip a topic of co-ownership. So in this case, I will say, no, the person cannot recover the entire 3,000 from one person because it is not a partnership. So it is a co-ownership. So this person will be liable only for 1,500. The other 1,500 should be recovered from the other part of the ownership. And it is not partnership. Is this clear, all of you? Pakka, done. Next one. X and Y were partners in a firm. The firm was dissolved on 12th June. But no public notice was given. Thereafter, X purchased some goods in the firm's name from Z. Z was ignorant of the fact of dissolution of firm. X became insolvent and Z filed a suit against Y for recovery of his amount. People, the partnership's liability will continue until a public notice is given about the dissolution. In this case, the public notice is not given. So the partner's liability will continue until the date of public notice about the dissolution. So partners liable, yes, liable. A, B and C are partners of partnership firm carrying on the business of construction of apartments. B, he who himself was a wholesale dealer of iron bars, was entrusted with the work of selection of iron bars after examining its quality. As a wholesaler, B is well aware of the market condition. Current market price of iron bar for construction is 350 per kg. B already had 1000 kgs of iron bar in stock, which he had purchased before price hike in the market for 200 per kg. He supplied the iron bars to the firm without the firm realizing the purchase cost. Is B liable to pay the firm the extra money he made, or he doesn't have to inform the firm as it is his own business and he has not taken any amount more than the current prevailing market price? What is the condition, people? Remember, a partner can never make secret profit. First one. Second one, a partner, if he makes any profit using the firm's connection, using the firm's name, using the firm's network, the partner has to refund that money to the partnership. So here, even though you have not made fraud, but you cannot make a secret profit. Either take the consent and do. If not, people, you are accountable to give that profit made to the partnership. Here, yes, you need to return the profits to the partnership firm, because a partner cannot make a secret profit. Clear? Okay. A and B were friends. Now they have plans of setting up a supermarket in their locality. They are confused as to whether to register as a traditional partnership or LLP. Give the difference between LLP and partnership. Basically, they are asking you the advantages of LLP. Okay, Mr. Dhruv was appointed as an employee of Sun Moon Timber Private Limited on the condition that if he were to leave his employment, he will not solicit the customers of the company. After some time, he was fired from the company. He set up his own business under proprietorship and undercut Sun Moon Timber Private Limited. Can anyone tell me which case law it is? Just by looking at it. The company hired one managing director. In that agreement, there was a condition that people that, when you leave the company, you are not supposed to solicit our customers. Can you tell me which case law it is? Which one? Yes, most of you are correct. They're asking you the case law of what, people? The case law of, people, Clifford Motor Company versus Horn. So whether Horn, whatever the activity he did, is it valid? Absolutely no, people. It is invalid. Fraudulent. Lifting of corporate wheel. So the company and Horn are not different. They are one and the same. That is a case law. Correct? Okay, AK Private Limited has borrowed 36 crore from BK Finance Limited. However, as per MOA, AK Private Limited, the maximum borrowing power of company is 30 crore. Examine whether AK Private Limited is liable to pay this debt. State the remedy, if any, available to BK Finance Limited. So people, in my MOA, it is clearly written I cannot borrow beyond 30 crore. So what is the maximum I'll be liable to? I'll be liable to is 30 crore only, not beyond that. So what is the alternative I have? I can file a case on the directors because it is their fault. Why did they go beyond that? So I can hold the directors liable. And not only that, imagine if the directors are going beyond MOA. What I can do? In your remedies for breach of contract, you would have seen one right you have. The right is for people to get injunction order. Order of injunction, meaning stop the company from going against their MOA. You can get an injunction order. You can stop the directors from doing whatever they're doing. So these are the two remedies. File a complaint against the director, make them personally liable, and you can file an order of injunction. Done. Mike LLC incorporated in Singapore, having an office in Pune, India. Analyze whether Mike LLC would be called a foreign company. Yes, people, a company which is registered outside India, has a place of business in India, conducts a business activity in India, will be considered as foreign company. Negotiable. Sachin brought 1000 kgs of rice from Saurabh for 1,50,000 on 3 months credit. Yes, Rahul, correct. For this purpose, Sachin issued a promissory note to Saurabh on the same date payable after 3 months. On the date of maturity, the promissory note was dishonored. Saurabh filed suit for the recovery of the amount plus fees of advocate paid by him for defending the suit. Referring to the provision of Negotiable Instrument Act, what amount could be recovered from Saurabh? People, I can recover the promissory note money, plus I can recover the advocate fees, plus I can also recover 18% per annum as interest for delay in repaying this money. So these are the amounts that I can recover from the person. Is this clear? I hope all of you are understanding the next one. A purchased a watch from B. Okay. He issued a promissory note to B which was payable on demand, but no specific place for payment was mentioned on it. So where to pay it is not mentioned. On maturity, B did not present the promissory note for payment. As the promissory note was not duly presented for payment, whether A would be discharged from liability under the provision of Negotiable Instrument Act. Answer is yes, people. When is presentment not required? Whenever the place is not mentioned on the promissory note, I am discharged from presentment, people, and hence I need not have to present. And without presentment itself, people, I can recover my money. Done. Yes, that is my one RTP. Done. Let us quickly do the second one. Explain the type of contract in the following agreements. Okay. Rahul contracts with Banu for the supply of 10 tons of sugar, but before the supply is effected, the factory catches fire and everything is destroyed. What type of contract? What happens to the agreement, people? Void contract. Impossibility of performance. Subsequent impossibility. Contract comes to an end. A coolie in uniform picks up the luggage of Rohan out of the railway station without being asked by Rohan, and Rohan allows him to do so. Implied contract based upon the conduct of the parties. Valid contract. Obligation of finder of lost goods to return to the true owner. Valid contract, people. As per quasi contracts, it's a valid contract. Finder of lost goods. Hello. Next one. Amit, a minor, was studying in a college. On 1st July 2023, he took a loan of 1 lakh from Bhavesh for payment of his college fees. Any money taken by a minor for necessity, his estate will be personally liable. Provision is that. And to purchase books and agree to repay by 31st December. Amit possesses assets worth 9 lakh. My assets are liable. I have 9 lakh. On the due date, Amit fails to pay back the loan to Bhavesh. Bhavesh now wants to recover the loan from Amit out of his assets. Possible? Yes, possible. No doubt. Absolutely fine. Mr. Sham, aged 58 years, was employed in a government department. He was going to retire after 2 years. Mr. Dev made a proposal to Mr. Sham to apply for voluntary retirement from his post so that Mr. Dev can be appointed in his place. So he asked the government employee to leave his office and go so that I can be appointed. Mr. Dev offered a sum of 10 lakh as consideration to Mr. Sham to do this retirement. Mr. Sham refused at first instance, but when he evaluated the amount offered as consideration is just double of his cumulative remuneration to be received during the tenure, whether the above agreement is valid. So what happened, people? I have taken money to forcefully retire. Is this contract valid, people? Of course, no. Consideration opposed to public policy. Trafficking of public offices and titles. In that you will see. You cannot sell your public office, meaning you cannot sell your post. You cannot sell your job. If any such contract is made, such agreement will be considered as void. It's a void agreement. Clear? Unlawful to public policy. What will be rights with promisor in the following cases under Indian Contract Act? What will be the rights with the promisor? Sunil promised to bring back Jatin to life again. Possible, Ada. It's a void agreement. You will not succeed. Aman, impossibility of performance. Aman agreed to sell 50 kgs of apples to Raman. The loaded truck left for delivery on 15th March, but due to riots in between reached Raman on 19th March, due to which the apples were rotten. People, whenever there is a breach of contract and if the deterioration during transit. So I am discharged, people. I can hold you liable. The agreement is void. An artist promised to paint on the fixed date for a fixed amount of remuneration, but met with an accident and lost his both hands. In this case, people, I'm clearly saying, people, it's a what is that? Painting, people. So I'm assuming it's a normal paint and it's not a wall painting. So it's a skill. It's a void contract. So contract will come to an end. A void contract. Abhishek entered into a contract of import of toys from China, but due to disturbance in the relation of both the countries, the import from China were banned. People, void contract due to subsequent change in law. It's a void contract. So contract will come to an end. Seema was running a boutique in New Delhi. She has to deliver some clothes to her friend Kiran, who was putting up an exhibition in Mumbai. Seema delivered the sewing machine and some cloth to a railway company to be delivered at a place where the exhibition was to be held. So they have put it in a railway. Seema expected to earn an exceptional profit from the sales made at this exhibition. However, she did not bring this fact to the notice of the railway authorities, meaning she has just given the sewing machine to railway and she has not said why she is giving. The goods were delivered to the place after the conclusion of the exhibition. The railway authorities did a delay. The goods reached the exhibition later than what was expected. On account of such breach of contract, Seema wanted to sue railway authorities. Can she sue? Answer is yes. But people, not for the profits she has lost. She can sue it for ordinary damages because the special circumstance was not communicated. Hadley versus Baxendale. So whatever is ordinary, directly related, only for that you will be liable and not for what is indirect. Explain any 5 circumstances. Okay. Suraj guarantees Vikas for the transactions to be done between Vikas and Nikhil during the month of March. Vikas supplied goods of 30,000 on 1st March and 20,000 on 3rd of March to Nikhil. On 5th March, Suraj passed away. On 10th March, being ignorant of the death of Suraj, Vikas further supplied 40,000. On default in payment, Nikhil on due date, Vikas sued legal heirs of Suraj for recovery of 19,000. Describe whether legal heirs of Suraj are liable to pay 90,000. People, this is nothing but people, a contract of continuing guarantee. The continuing guarantee will come to an end after the death of a surety. After that day, whatever are the contracts entered, the guarantee will not be liable. So does the legal heirs also will not be liable. So in this case, 40,000 happened after the death. So the liability of the surety will be only to the transactions that took place before the death. That will be people 30,000 and 20,000. So the legal representatives will be liable to the 20,000 and 30,000 and not the 40,000. However, also remember the legal representatives will be liable only to the extent of assets inherited from their ancestors. So what is assets inherited? I have inherited only 45,000 worth. Excuse me. So I'll not be liable for 50,000. My liability will be restricted for 45,000. Mr. Stephen owns a chicken farm near Gurugram where he breeds them and sells eggs and live chicken to retail shops. Mr. Fleming also owns a similar farm near Gurugram doing the same business. Mr. Fleming had to go back to his native place in Australia for 1 year. Native place in Australia, rich fellow. He needed money for travel, so he had to pledge his farm to Mr. Stephen for 1 year and received a deposit of 25 lakh and went away. At that point of time, the stock of live birds was 1 lakh birds and eggs were 10,000. The condition was that when Fleming returns, he will repay the deposit and take possession of his farm with live birds and eggs. This is nothing but people pledge. Also remember, pledge includes bailment. Correct? What do you mean by pledge? Pledge is nothing but bailment of goods for security. It's called as pledge. Agreed? So in this case, what I am telling, I am giving 1 lakh, what is that? Birds. Birds. Okay, 1 lakh birds I am giving, and I am giving 10,000 eggs. With the condition that after 1 year I'll come back, I'll give back your money. You have to give back my, what is that? Birds and eggs. Okay. After 1 year, Fleming came back and returned the deposit. So he gave back the 25 lakh. At that time, there were 1 lakh 9,000 birds. When I gave, it was 1 lakh. Now it is 1 lakh 9,000. You should know by now, people, in bailment, any accretion, surplus or profits that are caused of the product that is given by the bailer to bailee, the bailee has to return the accretion, surplus or profits that is caused. So I have to give back this, people. I don't have a choice. So I have to give back 1 lakh 9,000 also. Along with that, even whatever the eggs, I have to give back everything. Simple, done. What this question now? AB Cloth House, a firm dealing with the wholesale and retail buying and selling of the various kinds of cloths, customized as per the requirement of the customers. They dealt with silk, organdie, okay, cotton, khadi, chiffon and many other different varieties of cloth. Miss Reema, a customer, came to the shop and asked for a specific type of cloth suitable for making a suit for her daughter's birthday. See, she came to the shop and asked for a specific type of cloth suitable for making a suit. People, this is nothing but implied condition as to quality or fitness. Meaning, when I have asked, it should serve my purpose and I should have relied upon your decision. Specifically mentioned that she required a cotton silk cloth which is best suited for the purpose. The shop owner agreed and arranged the cloth piece cut into as per the buyer's requirement. When Reema went to the tailor to get the suit stitched, she found that the seller has supplied her cotton organdie material. The cloth was not suitable for the said purpose. It was heavily starched and not suitable for making the suit at all. The tailor asked Reema to return the cotton organdie cloth as it would have not met the requirement. The shop owner refused to return. People, KVA tempter, as I told you, people, I can get back my money because it did not fit my purpose. Quality or fitness, I did not serve my purpose for what I have asked for. Hence, I can get back my money. Samuel purchased a television set from Arun, the owner of Gada Electronics, on condition that, people, same thing. Again, it is repeating. I'll not again go through. Suraj sold his car to Sohan for 1,75,000. After inspection and satisfaction, Sohan paid 75,000 and took possession of car and promised to pay remaining amount within a month. Later on, Sohan refuses to give the remaining amount on the ground that the car was not in good condition. Advise Suraj as to the remedy available him against Sohan under the Sale of Goods Act. After inspection satisfaction, Sohan paid 75,000 and took possession of the car and promised to pay the remaining amount within a month. Later on, Sohan refuses to give the remaining amount on the grounds that the car was not in good condition. Advise Suraj as to what remedies available to him against Sohan under the Sale of Goods Act. People, unpaid seller, people, I have a right to recover for the suit of the price. That is, I can recover 1 lakh. If he doesn't pay, I can recover the legal cost. I can also recover it with interest. That's all. Remedies available against the buyer. Akash purchased 100 kgs of wheat from Bhaskar at 80 rupees per kg. Bhaskar says that wheat is in his warehouse in the custody of Kishore, the warehouse keeper. Kishore confirmed to Akash that he can take the delivery of wheat from him, and till then he is holding the wheat on Akash's behalf. Before Akash picks the goods from warehouse, the whole wheat in the warehouse has flowed in flood. Now Akash wants his price on the contention that no delivery has taken place. People, nothing but the delivery can be of how many types? Deliveries of how many types? There are 3 types of delivery. One is what? What? Delivery, what are the different types of delivery? Delivery, symbolic delivery, constructive delivery. The question is, people, constructive delivery. So, acknowledgement. So, one person said, I am holding the goods on your behalf. So, it's a constructive delivery. The delivery has happened. You cannot recover the price. Sahil, Amit and Kunal were partners in a firm. The firm is a dealer in office furniture. They have regular dealings with Measures AB and Co. Okay. For the supply of furniture for their business. On 30th June 2023, one of the partners, Mr. Kunal, died in a road accident. The firm ordered Measures AB and Co. to supply the furniture for their business on 25th May 2023. So died after the contract was made. Now Sahil and Amit continue the business in the firm's name after the Kunal's death. The firm did not give any notice about Kunal's death to the company or the person dealing with the firm. Measures AB and Co. delivered the furniture to the firm on 25th July. The fact about the Kunal's death was known to them at the time of delivery of goods. Afterwards, the firm became insolvent and failed to pay the price of furniture to Measures AB and Co. Now, Measures AB and Co. has filed a case against the firm for recovery of the price of furniture. With reference to the provision of Indian Partnership Act, explain whether Kunal's private estate is also liable for the price of furniture purchased by the firm. People, after the death, people, whatever are the contracts, I will not be liable. So after the death of the partner, any contracts entered by the partnership firm, the partner or partner's estate will not be liable. Is clear, all of you? Done. State whether the following are partnerships under the Indian Partnership Act or not. A and B buy commodity X and agree to sell the commodity with sharing the profits equally. People, there are two people. Buying and selling, business is happening. Sharing of profits is happening. Hence, I will call it as partnership. Two firms, each having 12 partners, combined by an agreement into one firm. So, people are coming and they are coming it by an agreement. So, I will call it as a partnership firm. A and B, co-owners, agree to conduct the business in common for profit. A and B, co-owners, but they are agreeing to conduct the business. Generally, why do we say co-ownership is not partnership? Because there will be no business. Here that link, they will do business, it seems. So it is a partnership. Don't write it off as co-ownership alone. Some individuals form an association to which each individual contributes 5,000 annually. The objective is to produce clothes and distribute clothes free. No business, no partnership. A and B co-owners share between themselves the rent derived from a piece of land. No business here. And hence it is just a co-ownership and not partnership. Direct. Okay. A, B and C has decided to set up a new club with name ABC. Basically charitable. So Section 8 company. They plan to do charitable work. Okay. The company obtained the status of Section 8. Okay. However, on 30th September, it was observed that ABC club was violating the objects of the section clause. What powers does CG have? CG has a power to take away, revoke your license, wind up or amalgamate with any other Section 8 company. All that are the rights available to CG. HP Polytech Limited has a paid up capital divided into 6 lakh equity shares of 100 each. 2 lakh equity shares the company are held by central government and 1 lakh 20 are held by government of Maharashtra, that is state government. So 2 lakh plus 1 lakh 20, that is 3 lakh 20. Out of 6 lakh, 3.2 lakh is held by government. Hence it is a government company for sure. No Limit Private Company is incorporated as unlimited company having share capital of 10 lakh. Unlimited company. One of its creditors, Mr. Samuel, filed a suit against a shareholder, Mr. Innocent, for recovery of his debt against No Limit Private Limited. Mr. Innocent has given his plea in the court that he is not liable as he is just a shareholder. Always remember, people, in unlimited company, the creditor cannot directly go and file a case on the shareholder. The creditor has to always file a case against the company first. The company will recover the money and the company will give it to the creditor. And when will the shareholder be liable? The shareholder will be unlimitedly liable only when the company is not in a position to repay the debt. When will you know that? When the company gets into winding up, insolvency, only then I will be unlimitedly liable. So in this case, you cannot directly go and file a case against the shareholder. You have to file a case against the company. Liquidator will be appointed. The liquidator will recover the money from the shareholder and it will be given to the creditor. That's the right way to do it. I hope this is clear. Clear? Hello? Done. Next one. Manoj purchased some goods from Sagar. He issued a check to Sagar for the sale price on 14 June. Sagar presented the check in his bank and his bank informed him on 19 June that the check was returned unpaid due to insufficiency of funds. Sagar sued against Manoj under section 138. State with reasons whether his suit is maintainable. Answer is yes, people. Any legally enforceable debt. If you file a case within 3 months, then yes, people, you can recover the money. Because beyond 3 months, you cannot do it. So in this case, yes, it is fine. You're done. Okay. Next one. The third one. Hey, I hope you're able to follow it quickly. I'm trying to do that so that you guys see different perceptions and different types of questions being asked on a topic which you guys would have already studied. Clear? Okay, Mr. Sohan, a wealthy individual, provided a loan of rupees 80,000 to Mr. Mukesh on 26th Feb 2023. The borrower, Mr. Mukesh, asked for further loan of 1,50,000. Mr. Sohan agreed but provided the loan in parts of different dates. That is 1,00,000 and 50,000. On 10th March, Mr. Mukesh, while paying off the part of 75,000, Mr. Sohan insisted that the lender should adjust 50,000 towards the loan taken on 3rd March. And balance against the loan on 26 March. Mr. Sohan objected to his arrangement and asked the borrower adjust an order to date of now you decide whether the contention of Mr. Mukesh correct or otherwise as per the provision of Indian Contract Act. Answer is yes, people. Appropriation of payment. The first option is always given to first option to the debtor, second option people, circumstances, third option people, creditor, fourth option people, first in, first out. Appropriation of payment, very important from exam point of view. What would be the answer in case borrower does not insist on order? Then it will be the order decided by the creditor. What would be the mode of adjustment or appropriation if neither creditor nor debtor insist? Then FIFO, first in, first out. That is in the order of first in, first out. Rama directs Shyam to sell laptops for him and agrees to give Shyam 11%. How many of you have watched the MTP series? In that this question was there. How many of you have watched? All of you have watched this question on MTP? So you tell me, logically, should I take up this question or should I say that, hey, go and watch it there? What do you want me to do? But yes, nonetheless, I'll do. Rama directs Shyam to sell laptops for him and agrees to give Shyam 11% commission on the sale price fixed by Rama for each laptop. As Government of India puts restriction on import of laptops, Rama thought that the prices of laptops might go up in near future and hence revokes Shyam's authority for any further sale. Shyam, before receiving the letter at his end, sold 5 laptops at the price fixed by Rama. Shyam asked for 11% commission on the sale of 5 laptops for rupee 1 lakh each. Explain under the provision of Indian Contract Act whether sale of laptops after revoking Shyam's authority is binding on Rama or not. Your Visha. I asked you whether you saw MTP or not. Did you see? Whether Shyam will be liable to recover his commission from Rama? If yes, what will be the amount of such commission? People, when will the agency be effectively revoked? Only when the agent is aware of it. He gets to know about it. So the answer is, people, yes, the agency has still not yet come to an end. You will be liable for whatever the agent has sold. What will be the commission? 1 laptop is 1 lakh. I've sold 5 laptops and the commission is 11%. I need to pay 55,000 as my commission. Rohan found a valet in a restaurant. He inquired all the customers present there, but the true owner could not be found. He handed over the same to the manager of the restaurant to keep the valet safe. What is a case law? What is the case law? You guys have to remember the case law just like that. Which case law? Hallin versus Howler, the diamond case law. Whoever finds the lost goods will become the next to owner of the goods. So in this case, I will continue to be the owner. So the cashier cannot reject it. I have to get back the goods. So until the true owner is found, that I will only keep the goods. Paridhi, a minor falsely representing her age, enters into an agreement with an authorized laptop dealer, Mr. Mittal, owner of empty laptops, for purchase of laptop on credit amounting to 60,000 on 1st August 2022. She promised to pay back the outstanding amount with interest at 16% per annum. She told him that in case she won't be able to pay the outstanding amount, her father, Mr. Ram, will pay back on her behalf. After 1 year, when Paridhi was asked to pay the outstanding amount with interest, she refused to pay, saying that she is a minor. She will be a major on 1st January and only after that agreement can be ratified. Explain by which of the following ways Mr. Vittal will succeed in recovering the amount. By filing a case against Paridhi, a minor, for recovery of outstanding. Will he? Answer is no. Mohri Bibi versus Dharmodas Ghosh. Any minor agreement is void ab initio. By filing a case against Mr. Ram, father of Paridhi, for recovery of outstanding amount. Minor cannot bind guardians, so the father or the parents will not be liable. By filing a case against Paridhi, a minor, for recovery of outstanding amount after she attains majority, minor agreements cannot be ratified. So in none of the case the person will succeed. State with reasons whether the following agreements are valid or void. Where two courts have jurisdiction to try a suit, an agreement between the parties that the suit should be filed in one of those courts and not in the other. It is a valid contract. It is not agreement in restraint of legal proceedings. I am allowing you to file, but in the two courts you have to file a case on one. You have to go to one court, not the other court. Such agreement is valid or invalid? It is still valid only. It is valid. Next one, X offers to sell his Maruti car to Y. Y believes that X has only WagonR. People, bilateral mistake, void agreement. X a physician, a mistake of fact, subject matter. X a physician and surgeon employs Y as an assistant on a salary of 75,000 per month for a term of 2 years, and Y agrees not to practice as a surgeon and physician during these 2 years. As an employee, people, agreement in restraint of trade, business, profession, as long as your employee is valid. Hence, it's a valid agreement. R owns an electronics store. P visited the store to buy a water purifier priced at 54,000. He specifically requested R for a purifier with a copper filter. This, I have done it in MTP. I'm telling you guys to go and watch it this time. Watch it. Yeah. What are the conditions? Okay, this is done direct. Let us not do. Shubhangi went to a jewelry shop and asked the sales girl to show her a diamond necklace with sapphire stones. The sapphire song. The jeweler told her that we have a lot of designs of diamond necklace but with the blue stones. If she chooses for herself any special design of diamond necklace with blue stone, they will replace the blue stone with sapphire stones. But for sapphire stone, they will charge some extra cost. Shubhangi selected a beautiful designer necklace and paid for it. She also paid the extra cost for sapphire stones. The jeweler requested her to come back a week later for delivery of that necklace. When she came back after a week to take delivery of necklace, she noticed that due to sapphire stones, the design of necklace had been completely disturbed. Now she wants to terminate the contract. Thus asked the manager to give her money back. So state with reasons whether Shubhangi can recover. Answer is yes, she can recover. Because the condition is clear that this is what is my condition. The condition is not met. Quality of fitness does not suit my purpose. What would be your answer if jeweler says that he can change the design but he will charge extra cost? He cannot charge the money, people. It is your duty to make good the default. So you cannot charge for it. Yes. J, a wholesaler of premium basmati rice, delivered on approval 100 bags of rice of 10 kg each to a local retailer on sale or returnable basis within a month of delivery. The next day, the retailer sold 5 bags to a rice of regular customer. Again, we have done this in MTP, requesting you to watch it once. Mr. Kanchan, MTP, it is done, watch it once. Clear? Because we have done it again, same thing, why repeat? New questions will take it up. Ravi sold 500 bags of wheat. People, but what do you guys think? Is this helping you? Is it not helping you? Question number 1. Question number 2. What more you think you need to give a confident attempt? And tomorrow again I'm telling you we are doing the writing practice. Apart from that, what more you think you need to write a confident attempt? You put it in the comment section below. And by the way, I hope you know that I gave you, a lot of people were asking me, sir, give us your chart book. And I gave the chart book also to you. If you guys have missed it, just go and see in this Mission 80, the second day, we have uploaded the chart book. In our first day, in the marathon itself, the chart book is made available. So go and get your chart books if you guys want it. Yes, and it's free. But what else you want, you let me know. Ravi sold 500 bags of wheat to Tushar. Each bag contains 50 kgs of wheat. Ravi sent 450 bags by road and Tushar himself took remaining 50 bags. Before Tushar receives delivery of 450 bags sent by road transport, he becomes bankrupt. Ravi, being still unpaid, stops the bag in transit. The official receiver on Tushar's insolvency claims that the bags cannot be stopped. Decide the case. People, whatever is delivered, the 50 kgs, I cannot do anything on it. Whatever is the 450 kg which is on the way, it is still in a transit. Because it is still on the way, it is not yet reached. On that, can I exercise my right to stoppage in transit? Answer is yes. So the total contracted quantity was 500 kgs or 500 bags. In that 50 is delivered. Once delivered, on that I do not have stoppage in transit. For whatever is not delivered, I can exercise the right to stoppage in transit. See, that is how you need to write your provision. I can exercise right to stoppage in transit. Clear? Okay, direct. PQ and R formed a partnership agreement to operate motor buses along specific routes for a duration of 12 years. MTP. What is this? Perpetual losses. What can you do? You can go to the court asking for dissolution if there is a perpetual losses. That's the answer. Ram and Shyam are partners in a partnership firm styled as RS & Co. Gopal, a renowned businessman, is their common friend. MTP. What is this? Partner by holding out. At least for this you guys will go and watch. Go and watch. Partner by holding out. Next one, company. BC Private Limited and its subsidiary KL Private Limited are holding 90 and 70,000 shares respectively in PQ Limited. See how I will write a subsidiary company. BC and KL are holding PQ in PQ. They are holding 90,000, 70,000 shares. The paid up share capital of PQ is people 30 lakhs. That is 3 lakh shares. The total they have is 3 lakh. How much are they together holding? 1.6 lakh together they are holding. Okay. Analyze with reference to the provision of Companies Act whether PQ Private Limited is a subsidiary of BC Private Limited. Okay, BC Private Limited and its subsidiary KL. So KL is its subsidiary. Then yes, people, of course, PQ is a deemed subsidiary of BC. Of course. What would be your answer if KL Private Limited is holding 1,60,000 shares in PQ Private Limited and no shares are held by BC Private Limited? So what if 90 is not held? Directly KL is holding 1.6 it seems. Even then, people, it is a subsidiary, deemed subsidiary company. It is this order. It is still a deemed subsidiary. Narendra Motors Limited is a government company. Shah Auto Private Limited have share capital of 10 crore in the form of 10 lakh shares of 100 each. Narendra Motor Limited is holding 5 lakh 5,000 shares in Shah Auto Private Limited. 5 lakh 5,000, that is more than 51%. Is it a government company? Of course it is a government company. XYZ company incorporated under the Companies Act 2013. The paid up share capital of XYZ. Government of India is 20. I will not count 8%. I will count Government of Tamil Nadu. 20 plus 10, 30. I'll count Rajasthan, 40. I'll not count this. So I'm only holding 40%. So is it a government company? Answer is no. Mr. Y issued a check for 10,000 to Z which was dishonored. MTP. What is the consequence of dishonor of a check? Imprisonment of 2 years or fine up to 2 times of the amount of the check or both. So amount of check is 10,000. The penalty can go up to 20,000. Reliable Limited, an Indian company, is a global leader in petrochemical products. For payment of the sale price of machinery imported from again MTP. See, I'm telling you, see the commonalities. Yeah. So this is nothing but a question on inland instrument. Now the question for you, when will a instrument be considered as inland instrument? When the instrument is drafted, drawn in India, payable in India, or drawee resides in India. So drawn in India and payable in India or drawee resides in India. So this condition mandatory. In these two conditions, any one, then it is a inland instrument. Done. Next one, Sri Shivai Temple Trust decided to get renovation of the temple under trust. For this purpose, the president of trust discussed the budget. Again, people, MTP. What is this, people? This is nothing but charity, quid pro quo, exception to quid pro quo, people, charity. So when one person promises to pay another person some money as a charity, is it a valid contract? Yes, provided if the person has undertaken any liability. Case law you can quote here, Kedarnath versus Gori Mohammed. Yeah. Sahil deals in pre-owned cars. Raju sold his accidental car to Sahil by fraud. My God. Sahil could not find that the car was accidental. So Sahil sold it to Raju. No. Raju sold it to Sahil. And Sahil further sold it to Akshay. This was fraud. Akshay informed Sahil his intention with condition that car should be free from any accident. Sahil sold that car to Akshay on erroneously believing that the car did not face any accident. Afterwards, Akshay found that the car was actually an accidental case. He sued Sahil to avoid the contract and also for damages for expenses suffered on car. Taking into account the provision of Indian Contract Act, state whether Akshay was eligible to avoid this contract. The answer is yes, people. This is misrepresentation. Because Sahil was also not aware that the car was, a accident car. Even Sahil was also not aware of it. Hence, the Sahil sold to, Akshay, thinking that the car is fine because he thought it is fine. So it's a misrepresentation. Can I avoid the contract? Yes, the contract is voidable, but you are not eligible for any compensation. Compensation will come into picture only if fraud is involved. Yes, I can avoid the contract. Rahul is manufacturer of jute bags. He contracted with Sonia to supply raw jute for the purpose of making bags. Rahul informed Sonia that production process of jute bags would start from 27th June. But Sonia must supply the raw jute on 25th June so that the quality verifications can be done in the next 2 days. Sonia supplied the jute on 27th June only. Breach of contract. And informed Rahul that she couldn't supply on 25th June due to some unavoidable reason, and she also assured that the quality measures were not anyway compromised in supplies. But Rahul wanted to avoid the contract as he was not given opportunity to examine the goods. In light of the Indian Contract Act, whether Rahul can avoid? Answer is yes. Breach of contract, failure to perform within the reasonable time. When time is essential, I can avoid the contract and hence the contract is void. It can be considered as void. You can cancel, you can resign the contract. Mr. Janta Machine Tools and Company contracted with Measures Ruchi Traders to make and deliver certain machinery by 31st July for 15 lakh. There was a labor strike in the factory of Measures Janta Machine Tools and Co. and it could not manufacture and deliver the machinery to Measures Ruchi Traders. It was a labor strike. Okay. Afterwards, Ruchi Traders had to purchase the machinery from another manufacturer for 18 lakh. Measures Ruchi Traders was also prevented from performing a contract which was made with Measures Shiksha Technologies at the time of the contract with Measures Janta Machinery Tools and Company were compelled to pay compensation of 2 lakh to Measures Shiksha Technologies. Measures Janta Machine Tools and Co. was very well informed by Measures Ruchi Traders about its contract. I can recover ordinary damages also. I can recover special damages also because the special circumstance was communicated. I've told that there is an ongoing contract. So even after telling them if you do not, I can recover special damages. Ankit has taken a loan of 1 lakh from Kishore on the guarantee of Sudeep at the interest of the rate of 12%. After some time due to financial crisis and at his request, Kishore reduced the rate of interest to 8% and also extended the time of repayment of loan without the consent of Sudeep. Ankit becomes insolvent. Whether Kishore sue Sudeep for recovery of the amount under the provision of no people, surety will be discharged if there is any variation in the contract. Ram Bilas Yadav is a farmer. Anna Chips company approached him and entered in a contract to supply 100 quintals of potatoes which to be grown in the fields belonging to Ram Bilas Yadav at 1000 per quintal. Anna Chips company made the payment of price but delivery to be made after 6 months. Okay, they have entered into a contract today but delivery in the future. Before the time of delivery, the whole crop of the potatoes were destroyed due to flood. Anna Chips company demanded the payment of price which it already made by it. Ram Bilas Yadav denied retaining the price by saying that the contract of sale was already entered and hence crop belonging to Anna Chips company. Hence loss of crop must be borne by it. Referring people. Remember, it's a agreement to sell. It's a future goods. The ownership will not transfer until the goods are future goods. So until it is produced and until it is ascertained, the ownership will not pass. So here the ownership will always be on the farmer only. So the risk will be on the farmer. Kapil entered into a contract with Rahul to purchase 1000 liters of mustard oil at the price which should be fixed by Akhilesh. Rahul already delivered 600 liters out of 1000 to Kapil but remaining 400 was ready to deliver. Akhilesh denied fixing the price of mustard oil. Rahul asked Kapil to return the oil already delivered and avoid the delivery of 400 liters. Kapil sued Rahul for non-delivery of remaining 400 liters. Advice in the light of Sale of Goods Act. People, whenever we have appointed a valuer to come up with a valuation, if the person is not able to arrive at a number, price, then we can avoid such contracts. We can set aside that contract. But however, if at all the goods are already delivered, if you have already given the goods, in such case, what will happen, people? If the goods are already delivered, correct? If the goods are already delivered, what will happen in such case? In such case, people, reasonable price should be paid for 600. This cannot be cancelled. 400 can be avoided. Saurabh purchased electric scooter of Vivek for 5,000 only on the gunpoint. Vivek decided to file the complaint and to avoid the contract on the basis of coercion applied against him by Saurabh. But before he could do that, Saurabh sold the scooter to Vinay, who had no idea about the situation on which the scooter was purchased by Saurabh. Vivek sued Saurabh and Vinay for recovery of scooter, referring to the Provision of Sale of Goods Act, whether Vivek was correct in his decision. People, sale of goods by a non-owner, nemo that quod non-habet, exceptions to that. A person in possession under voidable contract, the ownership can be properly passed. If the contract is not yet cancelled or rescinded, the ownership can be passed, and hence people, it is a valid contract. Amit and Ajay started the business of wholesale trading the sugar. For this purpose, they contributed 3 lakh and 1 lakh respectively. Partnership deed was perfectly prepared, but clause regarding the share of profit was not mentioned in the deed. Due to heavy rain, the stock of sugar was spoiled and firm incurred the loss of 60,000. Amit asked Ajay to contribute equally, but Ajay agreed to contribute only 25% of the loss in the ratio of capital. People, the profits and losses will always be distributed as per the ratio agreed by the partners in the agreement. If the agreement is silent, people, it will always be distributed equally, not in the profit, not in the capital ratio. So it is equally clear. So it will be equal. Yes. What is the difference between, okay, state giving reasons whether the following are partnerships or not. XYZ agree to divide the profits equally, but the loss, if any, is to be borne by X alone. Is it valid? Yes. Profits has to be mandatorily shared. Loss can be taken by one partner. It is allowed. It is okay. It is still a valid partnership. X, a publisher, agrees to publish a book at his own expense written by Y and to pay Y half of the net profit. Does this create a relationship of partnership between X and Y? X, a publisher, agrees to publish a book at his own expense written by Y. Okay, 1 second. Flickering is happening. Huh? Huh. Agrees to publish his book at his own expense written and by Y and to pay Y half of the net profit. Now, does this create a relationship of partnership between X and Y? So people, let us take a business is done by him, book at his own expense written by Y and to pay Y half of the net profit. People, you are just sharing like an interest, people. There is no business. There is no mutual agency. There is nothing. So I cannot call it as a partnership. Current is going. A and B purchase a tea shop and incur additional expense for purchasing utensils, each contributing half of the total expense. The shop is leased out on daily rent, which is divided between both. Does this arrangement constitute a partnership? Of course, no. It's a lease. Are they doing business? Answer is no. They're just giving it out and someone else is doing the business. So is it a partnership? No business is happening. Ratanmul Milk India Limited is a public company and formed on on this day Mr. Sharman was appointed as legal advisor of the company. It was mentioned in the articles of the company that Mr. Sharman will not be removed from the post of legal advisor till 31st March 2027. On 1st July 2024, a special resolution was passed for the alteration in the articles and Mr. Sharman was removed from the company. Mr. Sharman filed a suit against Ratanmul for removal as legal advisor. Whether can company remove Mr. Sharman? People, remember people, articles of association is always an internal document. Legal advisor is an outsider. It will never bind the outsider to the company. It is always for the shareholders. This particular articles are there. Anything written in articles, people, it does not create any contract between company and an outsider. So in our case, people, it will not bind the legal advisor to the company. So can we remove him? Yes, we are free to remove because it is written in articles of association. It does not create a contract with him. So we can remove. XYZ was incorporated to hold MTP, dormant company. It cannot be a dormant company because they have invested 1 crore. Go through the question. There is a significant accounting transaction. So it cannot be a dormant company. Priyansh purchased some goods from Sumit. He issued a check to Sumit for sale price. Sumit presented the check in his bank and his bank informed him on 19th June. Just now we saw dishonor of a check. A promissory note payable at certain price. Done. Last one, people. Taka will do. Come on. Albert obtained 2 loans of 3 lakh and 4 lakh respectively. People, again, we just did appropriation of payment. Okay, CA Sarthak Jain has decided to get interior work for his new office. For this purpose, he entered into a contract with Measures Sharif Fine Interiors. It was agreed that Measures Sharif Fine Interiors will complete the interior work up to 31st Jan 2025. On 31st Jan 2025, CA Sarthak Jain observed that only 20 to 30% work is completed. He decided to cancel the contract with Measures Sharif Fine Interiors. Sharif Fine Interiors filed a suit against the CA Sarthak Jain for recovery of the cost which he incurred on the interior work. CA Sarthak Jain argued that Sharif Fine Interiors did not complete the work within the time, and further the work done was of no use to him as he has to appoint a new interior designer. Explain whether CA Sarthak Jain is liable to pay the cost of work done. People, they are trying to confuse you with the quantum merit. But remember, this word plays a very major role. Which word? This one. If the 20-30 percentage, if it is of any use, then yes, I cannot say that I'll deduct you complete money and I'll not even give you 1 rupee. I cannot say that. But in our case, people, what has happened? In our case, whatever work you have done is absolutely unfit. I have to get everything redone. Literally everything is to be done from the scratch. In such case, whatever you have done, what is the use? So, can I cancel the contract? Yes. Should I pay some money? Absolutely no. Is clear? Done. Rohan of 17 years has purchased a mobile of 25,000 for his online classes from Mobile Sales Center on credit. Online classes. Education. On the due date, he did not make the payment of mobile. Mobile Sales Center sued Rohan and his parents. Minor cannot bind guardians. Rohan has 15,000 as his cash balance, but his father has enough money to pay the price. Examine the given situation. Minor will be liable for necessities, education. So whatever is my asset to the extent of 15,000, I will be liable. Akhil ordered 100 kgs of wheat to Measure Sahil Kirana store and it promised to supply the wheat by the evening. In the evening, the hawker of Measure Sahil Kirana store comes with, meaning dealer, with 100 kgs of wheat, but mistakenly he delivered it at the house of the neighbor of Akhil. Referring to the provisions of Indian Contract Act, advise who will be liable to pay the price of the wheat. People, quasi-contract people. Any person who has taken the benefit under mistake, you will have to repay it. Quasi-contract. So the neighbor has to pay the money. You don't have a choice. Rahul hired a car for 15 days from Measures Kushwa Travelers. After 5 days, Measures Kushwa Travelers demanded back his car. See, contract was entered for 15 days. They have asked back after 5 days. And people, it is hired. That is for money. So you don't even have to see the next part of the question. Whenever it is a bailment, hire is a bailment only, no? 2 types of bailment can happen. One is gratuitous, non-gratuitous. Non-gratuitous means, people, whenever bailment for money, for hire, such bailments, people, you cannot cancel it before the scheduled time. So in this case, you cannot cancel it as long as they have not done a misappropriation of goods. So in this case, no, you cannot cancel because it is a bailment for hire. Ajay appoints Vijay to sell his electronic goods lying in his godown. He also agrees to give 10% commission on sale price to Vijay. Afterwards, Ajay revokes Vijay's authority by sending the letter to Vijay. Revocation of agency. When will it be effective? Whenever the agent gets to know. That laptop, same thing. Mr. G sold some goods to Mr. H for a certain price by issue of an invoice, but payment in respect to the same was not received on that day. The goods were packed and lying in the godown of Mr. G. The goods were inspected by H's agent and were found to be in order. Later on the day, dues, the goods were settled in cash. Just after receiving cash, Mr. G asked Mr. H that goods should be taken away from his godown to enable him to store other goods purchased by him. After one day, since Mr. H did not take delivery of goods, G kept the goods out of the godown in open space. Due to rain, the goods were damaged. Who will bear the loss? People, when does the ownership transfer? Risk prima facie transfers with the ownership. So people, delivery and price is irrespective, people. Once the goods are ascertained, appropriated, the ownership transfers. But people, remember the seller's duty as a bailee to keep the goods safe. You are always liable. But provided he took a reasonable care of the goods, but he had to keep it outside because he had to keep some other goods inside. So because of that, I kept outside. So will I be liable for that? No. As a bailee, I have taken proper care of the goods. So who will be liable? People, the buyer will be liable. The seller will not be liable. Measure SEMA 125 kg MTP. We saw it today also. Raghav arranges an auction to sell an antique wall clock. Deepa, being one of the bidders, gives the highest bid for announcing the completion of sale. The auctioneer falls the hammer on table, but suddenly hammer breaks and damages the clock only. People, in auction, people, when does the ownership pass? When the hammer hits the table 3 times or whatever is the customary. Here it is not yet done. So people, the sale is not yet done. So the seller will only be liable, not the buyer, because the sale has not yet happened. X contracted to sell his car to Y. They did not discuss the price. What is it, people? Reasonable price is to be paid. A and B are partners in measures A, B and company. Firm is doing business of trading of plastic bottles. A is authorized to sell the stock of plastic bottles. It was decided between them that A should sell the plastic bottles at a minimum price which they have decided, and if A sells at a price less than the minimum price, he should first take the permission of B. Due to sudden change in government policy, the price of plastic bottles was continuously declining. To save the loss of the firm, A sold the stock at a lower price. Meanwhile, A tried to contact B but could not do so as B was on a foreign trip. Afterwards, B came and filed a suit to recover the different sale price and minimum price of the firm. Whether B can do so under provision. Indian Partnership Act, people, answer is no. Partner can sell or can go even beyond his authority during the necessity. So here the commercial necessity, I tried calling you, you were not reachable. In such case, what do? B cannot recover because partnership by necessity, I can do anything, you are liable. Done. Ram and Rahim, Ishwar Chand, we just did today only. Not even RTP, today only we did it. PQ and R formed a partnership agreement, 12 years, people. Perpetual losses, MTP, we have done this. A and B operate a textile merchant business in partnership. Mr. A finances the business and is a sleeping partner. MTP, we have done this. Tycoon Private Limited, again we have done this. MTP, watch it. In the Flower Fans Private Limited, there are only 5 members. All of them went on a pleasure trip. Again, we have done it. What is this, people? 5 shareholders go on a trip. All of them die. Will company come to an end? No, perpetual succession. The legal heirs will continue the business. An employee, Mr. Karan, signed a contract with his employer company that he will not solicit the customers after leaving the employment from the company. Today only we did Gifford Motor Company versus Horn. Pacific Motors Limited is a government company. Rama Auto Private Limited is a private company having share capital 10 crore in the, just now, today only we did it. A subsidiary of a government company is a deemed government company. See, that's why I say questions will repeat. That's why I say now see, you see 5 MTPs, 5 RTPs. It's like seeing 10 question papers, da. See, the questions are repeating, no? Getting my point? Yeah? Aman drew the bill on Baban, MTP. We have done this. Reliable Limited. Today only we did. Is it an inland instrument or a foreign instrument? It's an inland instrument. Done. Dana. Macha Danda. 5 RTPs. People. So let me know if you guys want to see anything else. You want any other support. But make sure you guys make it count in law. Tomorrow I will be presenting how to present the answer. I will write and show. Yeah? Sir, will you write only one answer? No, I'll write 2, 3. How many you want me to write? We'll write at least 3 answers. We'll at least write by practicing 3 answers. So even I'll try to become a student. We'll see how I will write. And you also see. And see, let us learn something out of it. Apart from this, if you guys want something else, do let me know. Yes. So thank you so much for today. Let us meet tomorrow session. See you all people. Bye-bye.